All right. So, hey, everyone, it's Russ Thornton with Wealth Care for Women. Excited today to be joined by Michael Salazar of Trust and Will. As some of you watching this will recognize, Trust and Will is a estate planning platform that I've introduced to some of you. And I was looking forward to the conversation with Michael today just to share with those of you who aren't familiar with Trust and Will a little bit more about who they are, what they do, and how it might be a good fit for your estate planning needs. So, Michael, welcome.
Yeah, thanks so much for having me, Russ. Looking forward to talking kind of the basics of estate planning and getting it a little bit into Trust and Will's platform. For all your viewers at home, they're probably looking at me thinking, hey, this guy's way too young. No way he's an attorney. You'd be right on both accounts. I am very young and I'm not an attorney. So please do not take anything that I say as legal advice. If you do want to receive legal advice and meet with an attorney, definitely recommend to meet with a local attorney and receive that advice.
Yeah, and everyone stick around to the end. Michael and I'll be sure to share more details on how you can learn more about Trust and Will or reach out to me if you'd be interested in starting your estate plan or updating your estate plan with the help of Trust and Will. So prior to hitting record, Michael and I had discussed some things that we wanted to cover. I've got some questions I'm going to throw at him. We're going to try to keep this kind of tight and concise so this doesn't just drag on forever. So we'll just kind of jump in and go from there. So Michael, I'm going to start with something that's pretty broad, but I think maybe sets the stage for the rest of our conversation. From your perspective, what is estate planning, or how would you define or explain estate planning to someone out there listening?
Yeah, great way to start. So setting up an estate plan is basically creating a plan for, first of all, when you pass away, what's going to happen to everything that you've worked so hard for, that you've accumulated through the years, whether that be your financial accounts, property, or other items like collectibles, family heirlooms, anything that you may own. Alongside that, it's also going to cover what's going to happen in a situation where you become incapacitated or go missing. So really, I like to think of having an estate plan as having peace of mind, of knowing that, hey, when I'm no longer here, the people that I care about are going to have some directions to go after and to follow. And that if I am here, but I'm not present, then the people that are closest to me are going to know what my wishes are and how I want them carried out.
So I like the idea of peace of mind. That makes sense to me. But I think you would agree that based on the pretty widely reported statistics, that estate planning is very underutilized by many Americans. You may have some stats you can throw out. So why, given the definitions you just shared with us, the peace of mind, giving instructions, making sure your wishes are carried out in the event that you're no longer around, why do you think more people don't put an estate plan in place for themselves and for their family?
Great question. And there's a lot of different reasons. First of all, it's uncomfortable to think about. It's uncomfortable to talk about. The fact that, hey, one day you're not going to be here anymore. So I think that's the primary reason why most people don't take that first step, or at least try to learn more about why estate planning is important. The other reasons really come down to kind of the system that has been in place in the United States for so long, which is that you need to meet with an attorney in person in order to set up an estate plan. There's going to be some barriers there. First of all, it is very expensive. Usually to set up a trust with an attorney in person is going to cost about $3,000 to $5,000. A lot of people don't really see the value in setting it up right now versus saying, hey, I can just wait later to do that. Another one is a time constraint. It takes a while in order to set this up. Sometimes, a 4 or 5 hour meeting in order to go through the process of creating your documents with an attorney. You have to take into account that people have to take off work, find a sitter for the kids. There's a lot of reasons why people don't take that first step ultimately to create an estate plan that's right for them. And that's a big reason why Trust and Will exists. Over 60% of American families don't have any sort of documents in place. Our mission here is not to, replace estate planning attorneys or make them go extinct. The goal for us is let's make sure that estate planning is accessible for everybody. So that's really what you're going to get out of working with Trust and Will.
Got it. That's super helpful. And I think that maybe sets the stage to transition into my next question. As I mentioned at the outset, my firm is Wealth Care for Women. I don't work exclusively with women, but They represent the majority of my clients, either women who are on their own or happily married couples. Um, and women consistently tell me that they don't want to be a burden on their children. Um, how can estate planning help address that concern that is often expressed?
Yeah, I think that's a super common concern that people across the country are feeling, that they don't want to be a burden on their children. The easiest way to avoid that is having a plan in place, right? So if you have a trust, you're going to completely avoid probate, which I think we'll talk about in just a little bit, but avoid that long, drawn out process of gathering all the information about your assets, paying off debts and taxes, getting family members maybe coming out of the woodworks to claim that they may be owed something. A trust and setting that up is going to ensure that everything gets passed along as smoothly as possible, and that probably most of your beneficiaries have to do minimal work in order to eventually receive those assets. Going down to a will, if you just have a will in place, your estate is still going to need to be probated, but you're going to have something to go off of, right? The people that you care about, specifically in this case, your children, are going to know what your wishes were, and working along with the judge and their attorneys, they're going to be able to distribute that estate, hopefully along with your wishes. So if you do pass away intestate, which means without a will or without any sort of estate plan, it's going to be a guessing game. Your family is not going to know what assets you have, right? If there's maybe some accounts that they didn't know about. And then they're also not going to know what your wishes were, how you want everything passed along, how you want it distributed, if there's any charities that you want to support. So I would say it's really going to give you peace of mind to know that your financial legacy is carried out as you intend, and that it keeps the burden of playing that guessing game off your children's shoulders.
Got it. Now, so you just mentioned a trust and you mentioned a will. What are the what from your perspective? What are the key elements of a well-documented, comprehensive estate plan?
Yeah, absolutely. So an estate plan can look like a lot of different things. For the sake of this conversation, we'll keep it within the scope of pretty traditional, pretty straightforward estate planning, which is what Trust and Will specializes in. The most comprehensive plan that you can get is what we would refer to as a trust-based plan. That's going to include a revocable living trust. Revocable means that it can be edited or changed throughout any time in their life. So as their life changes, maybe they have a grandchild or a child, they move to a new state, they receive a large inheritance themselves, they can make sure that their estate plan reflects that. So the revocable trust gives them a lot more flexibility. It's also going to include a pour over will, which is essentially the same document as a last will and testament. In that document, they'd be able to nominate guardians for minor children or for pets, and leave specific wishes around things like final arrangements, funeral services, things like that. Also, they would be able to include information about assets that aren't held in the trust, like I mentioned earlier, maybe collectibles, family heirlooms, furniture, things like that. And then moving beyond just inheritance and financial legacy, they're also going to receive some documents that can give them peace of mind while they're still alive. For example, HIPAA authorization, so they can release medical records to trusted individuals in the event where they're not in a state where they can grant that authorization themselves. Second would be their healthcare directive or living will. You know, what decisions are going to be made if your client's in a situation where they can't make a decision for themselves, and which agents are going to have the power to actually make that call on their behalf. And then lastly, the durable power of attorney. In case I go missing or in case I become incapacitated, who's going to be able to step up and take over personal matters for me and financial matters for me? So who's going to actually be authorized to act in my best interest if I'm not able to do that?
Got it.
Mm-hmm.
So I'm sorry, go ahead.
So I was going to say, it's really comprehensive. Here at Trust and Will, we don't offer documents a la carte because we want to make sure people have peace of mind, not just for when they pass away, but also very importantly for when they're still here, but they couldn't make a decision for themselves.
But you guys, while the trust-based plan is the most comprehensive and includes everything you just covered, if someone doesn't want or doesn't feel they need a trust-based plan, they can also choose to just do a last will and testament along with the complementary documents that you just went through, correct?
Yeah, exactly. So if they don't want to set up a trust right now, if that's maybe something they want to do down the line, but they want to have some peace of mind with their last will and testament, and those healthcare documents that I mentioned, the power of attorney document as well, they can absolutely just do that and then upgrade, as you could say, to a trust down the road if they wanted to.
Got it. All right, cool. And you mentioned a couple, at least once, maybe twice, that you mentioned probate, and there are some ways that you can avoid it, and some reasons you might want to avoid it. So let's first start. Like, could you just take a moment and tell us what is probate, and how long does it take, and how much might it cost?
Yeah, absolutely. So probate is the process of administering someone's estate after they pass away. So if somebody dies intestate, which means they die without a will, or if they just have a will and no trust, more than likely their estate is going to need to be probated. It does depend on the state that you're in and the amount of assets that you have. But I am going to go ahead and maybe boldly guess that any clients that you're working with, their estate would need to be probated if they passed away intestate. So during that process, they are going to have to gather all of the information about your estate. Hey, what assets do you have? What property do you own? What debts do you still owe? What taxes do you still owe? And making sure that everything is paid off and that the estate is in a situation where it is ready to be distributed. Now, if you do die intestate, it's ultimately going to be up to a judge and the state to decide how your assets are distributed. Most people want to control their own legacy. They don't want to have the government deciding what their financial legacy is going to be. So for a lot of people, that's the main motivator, is avoiding that probate process altogether. Typically, we see it's anywhere from 2 to 7% of someone's total estate can be absorbed by the cost of probate fees plus attorney fees during that process. So it's definitely something you want to avoid if you want to ensure that you're maximizing the inheritance that you'd be passing along, or maybe that you would be giving to charity. So just as a rough estimate, we hear usually somewhere between like $10,000 and $40,000 as the average cost, again, depending on the state and the size of your estate. But I think the main motivator for people to avoid that goes back to something you talked about earlier, which is not being a burden. And if you pass away and your estate needs to be probated, that can cause a lot of unnecessary drama, division, financial stress, emotional stress, that really in that time, this is a time where people should be together, they should be healing, they should be reflecting, but instead, it could cause division and other conflicts down the road.
So that's helpful, and I think that provides some good context for some things you already mentioned, and something I just want to touch on again. So if someone, for what I would say all the obvious reasons, wants to avoid probate, what's the best way for a person or a family to avoid having their heirs have to probate their estate once they're no longer around?
Yeah, so really the best and only way is going to be to set up a trust, for yourself, for your family, and say, hey, we're going to make sure that everything's passed along exactly as possible. And I want to just point out some of the main benefits of having a trust over having a will. First of all is avoiding probate. Along with that comes ensuring that your information is kept private, right? Because if your estate is probated, that information is not necessarily going to be on the front page of the local paper, but it does become public record and people can access it if they want to. So a lot of people like to have that privacy for themselves, even though they're no longer here, or for their family, and say, hey, I'm going to set up a trust, make sure this information stays private when that transfer, that inheritance happens. And then the second one that I think really motivates people is the ability to control or have a little bit more control over distributions. Like if you have a will, your estate goes to probate, the judge says, yes, 50% of their estate can pass along to the son. Odds are the son's going to get everything all at once. Versus if you have a trust, you can set it up to say, hey, I want my son to get 33% of this estate, or 33% of his inheritance at the age of 30, 33% at 35, 33% at the age of 40, spread it out over time and make sure you're not giving someone a huge lump sum all at once. I think that's really what appeals to a lot of people, is having some more control over the distributions.
Got it. So a challenge in this conversation is to stay focused, because estate planning is more than wills and trusts and documents. It also touches things like beneficiary designations, which are super important. From your perspective, Michael, what would you say is more important, an estate plan or beneficiary designations on something like a retirement plan or a life insurance policy?
Yeah, I wouldn't say that one is necessarily more important than the other. In almost every single family situation that we see, they're going to have both set up. So they're going to have an estate plan set up, maybe for, a savings account, certain investment accounts, but then for a retirement account, life insurance policy, they're going to have TOD, transfer on death, set up, or they're going to have a beneficiary set up for their life insurance policy. And if those are set up, that doesn't necessarily need to be added to the trust. If you can transfer assets to the next generation through a TOD or through a beneficiary designation, that is a great idea. And you can absolutely roll with that. But if you do own property, have savings account, or a different type of account that doesn't allow for a beneficiary or a TOD to set up, definitely better to have it in a trust. So typically we're going to see them, if somebody does own their home or they own a small business, that's really going to be a huge motivator for them to say, okay, I've got my other accounts where I've got TOD, I've got beneficiary designations, but for this property or for this small business, I want to make sure that that's handled the correct way as well.
Got it. Got it. I've got a few more questions, and we're already kind of pressing the targeted time limit. So let's see if we can run through a few more of these. What's included in a person's estate, and maybe just as importantly, what's not included in their estate?
Yeah, great question. So it's what we mentioned earlier, what you think of right away, right? Property, small businesses, any retirement accounts, financial accounts, investment accounts, life insurance policies, collectibles, family heirlooms, vehicles, furniture, really anything that you own. In addition to that, I think something that often gets overlooked is your digital footprint, right? So all of your email accounts, all of your photos that are online or on the cloud, that's all part of your estate as well. And don't want to spend too much time on it, but through trust and will, and with probably most attorneys by now, you're going to be able to actually assign a digital executor. So you can actually give someone the responsibility to say, hey, when I'm gone, I want you to handle my digital footprint, memorialize my Facebook page or my Twitter page, maybe delete those accounts, right? Share the photos from this album in my iCloud with my family members, whatever it may be. You can actually give someone a control to say, hey, I want you to be able to manage my digital footprint, shut down my accounts once I'm no longer here. So that's something that often gets overlooked. Definitely not the most important part of an estate plan, but you do need to think of your estate as everything that you own.
Got it. Got it. And I want to highlight something real quick that you mentioned, which is life insurance. Life insurance proceeds. So if you've got $1 million term life policy, those proceeds go to your beneficiary or to your heirs tax-free, but the value of that policy, the $1 million, is still included in your estate. Given the exemption limit these days, very few people have to deal with a taxable estate, but it's something to keep in mind. And those numbers might be coming back down here in the next couple of years as well. What happens, Michael, and you touched on this a little bit earlier, what happens if you're alive but incapacitated?
Mm-hmm. So that's where they're going to probably get in contact with family members and start to look for that document that I talked about earlier, the healthcare directive or living will. And that's going to cover, hey, if this situation occurs, like if I am what some people may call on life support, what decision do I want made? If I'm in a state where there is no path to recovery and I'm simply being kept alive by a machine, what decision do I want to be made? Do I want to stay in that state for as long as possible? Or do I want one of my family members to evaluate and then ultimately have the power to, as some people know, pull the plug? That's why having that healthcare directive in place is so important, to know that, hey, even though you're not in a state where you can't make that decision for yourself, you're incapacitated, you can't tell the doctor what to do, you can still, in a sense, have total control over that situation.
Got it. And the powers of attorney come into play too, because if you're incapacitated and your financial matters or other matters still need to be dealt with, it's good to have someone appointed that can take over the reins.
Yeah, exactly. Like if you have credit card payments that are due that the next day, then your financial power of attorney could step up and make the moves necessary on your behalf.
Got it. Michael, you good for a couple more questions as we start to wrap things up?
100%. Yeah.
Awesome. Thanks. So we've talked a lot about what is estate planning, what are the moving parts, why someone obviously would want to consider putting an estate plan in place or making sure their estate plan is up to date. How does trust and will help with the estate planning process?
Great question. So we are in the document creation business. We can help you create your estate plan. So we take you through one question at a time. It really keeps things light. It prevents you from feeling overwhelmed or like you're filling out a big, long, complicated form. Based off the information you provide us, we're able to know what other questions we need to ask and build a state-specific, customized, comprehensive plan in usually about 30 to 45 minutes if you do it all in one sitting. The whole time you are going to have access to live support via our team. That's through chat, phone, or email. In certain states, you can also add attorney support to receive legal advice and go through document review with a vetted estate planning attorney for a small additional fee. That's really where we step in to help out, is making sure that document creation is as easy as possible, that we have education built into the process so clients can learn as they go, and to make sure that we're delivering totally customized, comprehensive, state-specific documents to anyone that needs them. We're definitely going to be built for people that have more straightforward needs. If you do have a more complicated situation, like, maybe you own property in 4 states, or you have a really complex blended family structure, or maybe one of your children has a disability, definitely better to set up a special needs trust with an attorney in that situation. There's always going to be situations where an attorney is, the better fit. Being a digital platform, we definitely have limitations to what we can do. But for an American family that owns their home, maybe a small business, they have 2 kids, and they want to set up a trust and will is going to be able to help with that.
Great. And so let's say someone watches this and they're like, yeah, I need to put my estate plan in place, or I need to update my estate plan. Trust and will sounds like a great fit. I invite you to reach out to me. I've got a link that I can share with you that'll actually get you a little bit of a discount on Trust and Will's pricing, and Michael and I'll touch on that in a moment. But let's say that someone says, Russ, I want to start the Trust and Will estate planning process. I send them the link. At a high level, Michael, what's the process? Well, I know you kind of touched on it just now, but like what would someone expect to experience going through the process of creating an estate plan through Trust and Will?
Definitely. So they'll click through your link. They'll set up an account using an email and password and select their plan. And then they'll answer one question at a time. They'll have access to education during that process. They'll have access to our support team, like I said, about 30 to 45 minutes on average. And then they can either print out the documents right away as soon as they're done, or what's more popular is request free shipping from us, wait 5 to 7 business days. We'll send them a physical copy of their documents. And along with the documents, they'll get instructions for notarization, so they know exactly what needs to be signed, what needs to be notarized, who their witnesses can and cannot be. And then if they got a trust with us, it'll include a trust funding guide. Mm-hmm. So they're going to know what the next steps are for retitling accounts, updating deeds for properties if necessary, making sure that their trust is properly funded and that they're ready to go. The feedback we typically get is that trust funding process is, the biggest headache causer or the most legwork for a client to do. It's going to be the same if you do meet with an attorney. 99 times out of 100, the attorney's not going to fund the trust for you. They'll just provide guidance on what needs to be done. But some advisors do like to say, hey, if you want a second set of eyes on this, I'm okay to review it. That's not considered legal advice from Russ. So, if you want a second set of eyes, or if you have questions, you can definitely still come back to our team and get some clarification or guidance.
Yeah, excellent. And one point I wanted to make that you kind of highlighted on is if you go through the process of setting up a trust-based plan, but you neglect to fully fund the trust, meaning retitle your home or your accounts, or even if you just miss one thing, that one thing can still trigger probate, even though you've done everything else right and have retitled everything else in the trust. So just be sensitive to the fact that if you go through the plan or the process to set up a trust-based plan, as Michael just highlighted, you still need to actually fund the trust, which involves retitling accounts, retitling the deed of your home and other properties and assets, so you can make sure that you actually do avoid probate and afford yourself the privacy benefits that he touched on. As we wrap up, Michael, clearly Trust and Will is not a charitable organization. There are fees to do will-based and trust-based plans. Could you just kind of cover what those look like right now?
Yeah, 100%. And I'm actually going to share my screen to make this a little bit easier.
Perfect.
You able to see that?
Yeah.
Perfect. So we offer two different plans to choose from: a will-based plan or a trust-based plan. The will-based plan is $143 for an individual, $233 for a couple. I know those prices look a little bit funny. That's because when Russ refers you, you're automatically going to get 10% off. So these are the prices you'll see with that 10% discount automatically applied. The next step up from there, the trust-based plan that we talked about, $539 for an individual, $629 for a couple. Again, typically we're hearing $3,000 to $5,000 to set this up with an attorney, depending on where you're based out of, who the attorney is. But again, you'll get a 10% discount. And then we do also offer live attorney review and consultation for an additional fee of $200 in select states. So if you wanted to ask for and receive legal advice, go through the process with an attorney, and even do line-by-line document review, that's only an additional $200. It's incredible value. Most attorneys will probably charge, somewhere between $300 to $500 per hour for legal advice.
Yeah, awesome. Thank you. And before we bring our conversation to a close, feel welcome if anyone has any questions, feel welcome to reach out to me. I can either connect you with Trust and Will through my link where you get the discount, or I'm happy to answer any questions or discuss estate planning with you or review your existing estate plan. I've had several clients go through the Trust and Will process and have gotten really good feedback, and we've had some really meaningful conversations along the way. Michael, in the interest of time, I think now is probably a pretty good place to wrap it up, although I think there is plenty of fertile ground we could additionally cover maybe in a future conversation. Thanks so much for joining me. This has been great. I hope for everyone out there watching, this has been informative. Any closing comments or thoughts, Michael, before we wrap it up?
Yeah, 100%. Thanks for having me. What I would say is have a conversation with Russ about where you're at right now, what you want your legacy to be, and how he can help you accomplish that, right? Because he does have this resource available to him now, Trust and Will, that he can help get you started on. If not, he can definitely help you get connected to and sat down with a local attorney that's going to be able to help you out. Our mission here is not to, like I said, replace estate planning attorneys. We want to be sure that this is something that's easy and accessible for you. So if you are interested, definitely reach out to Russ, let him know, and he'll be able to help get you started. But thank you so much for tuning in. Share a little bit about what you learned today with a family member, whether that's, a spouse, a child, a parent, a cousin, whatever it may be. The more we can talk about estate planning and normalize talking about estate planning, the more families are going to have the ability to start to build generational wealth.
Yeah. One final thing that came to mind based on Michael's comments. If you use Trust and Will, I do not receive any compensation. There is no revenue sharing. I don't have any incentive for you to use Trust and Will versus a local attorney, other than, as Michael said, if you've got a fairly straightforward situation, you can save some money. As he also mentioned, I do know some really great attorneys, both locally, and I have some context around the country as well. So if working one-on-one with a estate planning attorney is a better fit, I can help you find some good resources there as well. Michael, this has been great. Thanks. We went a little over our target time, but I think we covered some really important information. So thanks again. And for everyone else out there, thanks for joining us, and we will catch you next time.